Okay, welcome to the Data Practices Potpourri webinar. We are talking about body camera today. That is body cameras today and the data related to those devices. If you signed up for this webinar and you were not expecting to hear about body cameras, you may have mistakenly registered for this webinar. We are having another General Data Practices Potpourri webinar coming up on June 6th. And so if that was what you were expecting to log in and listen to today, I would encourage you to go back to our website, to that webinar page, scroll down a little bit, and then you can find the registration for the June 6th webinar, which we'll be doing in a couple of weeks. But today's session will be focused on body camera data. So thank you for joining us today. The Data Practices Office is a small office in the Department of Administration, and we're a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions related to those laws from members of the public and government. So if you have a question about those laws, please feel free to reach out to us at any time. We also help the Commissioner with issuing advisory opinions, and we provide legislative assistance and training. This PowerPoint is posted on our website, so if you aren't able to download a copy today, it is on the page where you registered. We also record our webinars, so if you missed part of today's webinar or want to go back and watch it again, or find one of our prior series, those videos are posted on the Data Practices Office YouTube page. We also have a dedicated body camera information page on our website, including an outline of body camera requirements and frequently asked questions. You can find more information at the URL listed on this slide, and we'll have another slide later with more information on accessing those resources after this webinar. All right, if you would like to download a copy of the PowerPoint right now, I'm going to share a file for you to download and save to your computer. Just give me one moment, please. Okay, you should see a pop-up window appearing on your device, and then you can select the file and download to your device. I know that for a lot of folks, this doesn't work. And so again, you can go to the web page where you registered for this webinar, scroll all the way to the bottom, and we have posted the slides there also. So that's another way that you can find and download those slides. Okay, today's webinar is going to focus on the requirements related to law enforcement body camera data. We'll start with a brief overview of some basic rules about body camera data before discussing some recent questions we've received about handling these types of data. We will leave some time for a Q&A session at the end of the webinar. So please feel free to send in your questions as you think of them using the Q&A panel on your screen. Make sure you choose all panelists when you send in your questions so we can be sure to see them. You can start sending your questions now, or you can wait until the end of the presentation. Let's start with some basic requirements that apply to handling body-worn camera data. Body camera videos are governed by Minnesota Statutes, Section 13.825, and are treated differently than other types of law enforcement data. Most law enforcement data are governed by Section 13.82, but the legislature determined that body camera videos should have additional protections due to the nature of body camera footage and the fact that these cameras may be worn while entering people's homes. The classification of body camera data depends on whether the data are part of an active or inactive law enforcement investigation. Section 13.825, subdivision 2A3, indicates that body camera data are governed by Section 13.82, subdivision 7, while an investigation is active. So, body camera data are classified as confidential or protected non-public while part of an active criminal investigation, and those data are not accessible to a data subject. Rather, the data may only be accessed by those within the government entity with a work assignment or those with statutory authority or court order. When there's no criminal investigation or the investigation becomes inactive, then the body camera data are governed under Section 13.825. Under this section, the body camera data are classified as private or non-public data, which I'll go into further depth on the next slide. However, in certain situations, Inactive body camera data become public if the data document an incident where an officer discharges a weapon in the course of duty, but that does not include training or killing a sick, injured, or dangerous animal. The data documents the use of force by a peace officer that results in substantial bodily harm. A subject of the body camera data requests the data become public. However, if the body camera footage documents other data subjects who do not consent to the release and they are not peace officers, those individuals must be redacted from the video. Body camera data that become public personnel data under Section 13.43, Subdivision 2 remain public, which would include public employee disciplinary data. Finally, body camera data become public when the data document an incident where an individual died as a result of an officer's use of force. I'll say more on this aspect in a couple slides. Subdivision 2 also mentions that body camera data may be redacted if the data are clearly offensive to common sensibilities. Law enforcement agencies may also release any not public body camera data to the public to aid the law enforcement process, promote public safety, or dispel widespread rumor or unrest under Section 13.82, Subdivision 15. This provision is generally what we've seen law enforcement agencies rely upon when releasing body camera footage while a criminal investigation is still active. Whether law enforcement used a body camera or any portable recording system is also public in the context of arrest data and response or incident data. To be clear, it's not the video data that are public, rather it's the fact that body cameras were used that is public data. As noted on the previous slide, body camera data that are not part of an active investigation are generally classified as private or non-public data. When government data are private or non-public, the data are accessible to the data subjects, those within the government entity with a work assignment, and those with statutory authority or a court order. Section 13.825, Subdivision 4, governs access to body camera data by data subjects. The subdivision states that a data subject includes any individual who can be seen or heard in the data, the peace officer who collected the data, as well as other peace officers who can be seen or heard. The subdivision goes on to indicate that data subjects have access to private or non-public data. So an individual whose image or voice appears in a body camera video can inspect the unredacted video, including viewing data on other individuals and peace officers who appear in the video, except for undercover peace officers. Note that the access or right to view the data under this subdivision is different than the data subject's right to obtain copies of the data. The data subject may only view the unredacted footage, but if they want copies of body camera videos in which they appear, the identities of the other data subjects must be redacted. This is an important difference between body camera footage and other private data, and it is due to the specific data subject and access language in this provision that does not exist anywhere else in the Data Practices Act. Again, if a data subject requests that body camera video be made accessible to the public, other data subjects, not including on-duty peace officers engaged in an investigation or response, must either give consent to appear in the public data or they must be redacted from the video. Law enforcement agencies must always redact undercover officers from body camera data. Lastly, there may be situations when no individual appears in body camera data. The body camera data would be classified as non-public data, and the law enforcement agency will need to determine whether there is a data subject, if any, who can access those data. For example, a peace officer may use a body camera to collect data when inspecting damage to a vehicle after an accident. In this situation, the data subject may be the owner of the vehicle because the owner is clearly connected to the car. As a result, the owner could likely be the subject of the non-public data and obtain access to those body camera data of the vehicle inspection. Additionally, the legislature amended Section 13.825, Subdivision 2 in 2023 to allow greater access to data that document deadly use of force incidents. Specifically, when an individual dies as a result of an officer's use of force, the officer's law enforcement agency must allow the deceased's next of kin, the next of kin's lawyer, and the parent of the deceased's shared child to inspect the data documenting the incident within 5 days of making a request. However, the agency may deny this inspection request if the agency determines there is a compelling reason for why such inspection would interfere with an active criminal investigation. If the agency denies access, then the chief law enforcement officer must provide a prompt written denial to the family and inform them of their ability to ask a court to grant them access under Section 13.82, Subdivision 7. The legislature's amendments also require a law enforcement agency to make body camera data documenting an officer's deadly use of force available to the public within 14 days after an incident occurs. However, the agency may withhold access to the body camera data if the chief law enforcement officer asserts in writing that the public classification would interfere with an ongoing criminal investigation. Data that are withheld would remain classified as confidential under Section 13.82, Subdivision 7. Normally, the Data Practices Act does not create specific data retention requirements, and entities must rely upon their record retention schedules to determine how long they must keep official records. However, Section 13.825, Subdivision 3, does create some minimum data retention requirements for body camera data. So, all body camera videos must be retained for at least 90 days. If body camera data document the use of force, discharge of a weapon in the course of duty, or there was a formal complaint against an officer, the data must be retained for a minimum of 1 year. Meanwhile, body camera data documenting a deadly use of force incident must be retained indefinitely. Once the 90-day and 1-year thresholds are met, law enforcement agencies must follow their retention schedules, which may require longer retention of the videos. However, Section 13.825 permits data subjects to request that a law enforcement agency retain body camera data for longer time periods. When an agency receives such a request, it must retain the data for up to 180 days and must notify the requester that the data may be destroyed unless the individual once again requests data to be retained. Your agency's required body camera policies should include information about requesting extended retention, and your internal procedures should address retaining body camera data for the minimum and extended retention requirements. In addition to what we've already discussed, there are several other requirements under Section 13.825 that law enforcement agencies should keep in mind. Agencies must maintain an inventory, which contains public data about the number of body cameras the agency owns, daily records of the cameras used and the precincts in which they were used, policies and procedures for use, the total amount of video data collected, the agency's retention schedule for body camera data, and the agency's destruction procedures. Subdivision 7 requires the responsible authority for law enforcement agencies to have written procedures that specifically outline access to body camera data. These procedures must ensure that law enforcement personnel only have access to not public body cam data if authorized in writing by the head of the law enforcement agency or their designee for a legitimate specified law enforcement purpose. Body camera data may only be shared with or disseminated to another law enforcement agency, a government entity, or a federal agency upon meeting the standards for requesting access to data as provided in Subdivision 7. Law enforcement agencies must also arrange independent biennial audits of their body camera data systems to determine whether data are appropriately classified, how the data are used, whether the data are properly destroyed, and verify compliance with Subdivisions 7 and 8. Law enforcement agencies must provide reports summarizing the results of each audit to specific legislative committees within 60 days of a completed audit. If law enforcement obtains new surveillance technology that expands the scope of surveillance capability with the body cameras beyond video or audio recording, the agency must notify BCA within 10 days. There are also certain vendor requirements outlined in Subdivision 11 and increased penalties for willful violations in Subdivision 12. Lastly, Section 626.8473 requires law enforcement agencies to allow the public to comment on a plan to purchase or implement body camera programs. The agencies must create written policies and procedures prior to implementing a body camera program, and the policies must include specific information as described in Section 626.8473, Subdivision 3. Finally, the written policies must be posted on the law enforcement agency's website if the agency has one. I do recognize that was a lot of information delivered pretty quickly. However, you can find some more information about these various requirements on the Data Practices Office website at the link on the bottom of this slide. And I'll just pause for a moment so you can write that down if needed. Okay, let's now turn to some of the questions we've seen over the past few months about body camera data. So our first question involves situations where an employee who is not a peace officer, such as a community service officer or building security staff, wears a body camera and captures data. The question is whether the video data collected by these employees would be governed under Section 13.825. No, data that are collected by non-peace officer staff who are wearing body cameras would not be governed under Section 13.825. Specifically, Section 13.825, Subdivision 1, provides the applicable definitions when thinking about body cameras, which the statute specifically calls portable recording systems. Under Section 13.825, Subdivision 1B, a portable recording system, i.e. body camera system, is defined as a device worn by a peace officer that is capable of both video and audio recording of the officer's activities and interactions with others, or collecting digital multimedia evidence as part of an investigation. In other words, the language of Section 13.825 applies only to the data that are created by devices worn by peace officers, and the section does not apply when other staff may be wearing body cameras. Rather, body camera data that are created by other staff, such as CSOs or security staff, would be presumptively public or governed under Section 13.82, meaning that a video could be confidential if the data are pulled into an active criminal investigation. However, the video data that other staff created with a body camera would become public once the investigation is inactive. All right, next question. How much of a person needs to be redacted from body camera data in order to comply with Section 13.825's requirements? So there's probably not a one-size-fits-all answer to this question. Rather, the amount of data that agencies need to redact will likely depend on the context of the data. Specifically, in the context of body camera data, Section 13.825, Subdivision 1B, Paragraph 3, defines redact as to blur video or distort audio so that the identity of the subject in a recording is obscured sufficiently to render the subject unidentifiable. In most situations, sufficient redaction may be to blur faces and to remove audio. Other times, there may be some unique aspects to the individual where more redaction is necessary, such as when the data shows someone with unique tattoos on exposed arms, or when a data subject is wearing a uniform with their name on it. In those situations, additional redactions may be necessary to ensure that a data subject is not identifiable. In short, your agencies must take appropriate steps to ensure that you've redacted enough data so that the data subjects in the video cannot be identified. Here's another issue that we've seen come up a few times over the past several months from both agencies and data requesters. Specifically, we've heard that some law enforcement agencies have a policy where they will charge a flat rate per video to cover costs related to redacting body camera data due to the fact that the redaction process is so time-consuming. The question we get is whether the agency can charge such a fee under the Data Practices Act. The answer here, the Data Practices Act does not allow government entities to charge any copy costs related to redacting data. Specifically, Section 13.03, Subdivision 3C, states that government entities cannot charge data requesters cannot charge data requesters costs related to separating public from not public data, which is a technical way to say redaction. Further, most requests for body camera data are going to be submitted by data subjects, and data subject requests are governed under Section 13.04, Subdivision 3. That subdivision states that government entities may require a data requester to pay only the actual costs of making and certifying the copies. Again, the language does not allow a government entity to charge costs related to redactions. In short, the copy costs that your agency is permitted to charge when fulfilling a body camera data request from a data subject is the costs related to making copies, such as the cost of a DVD disc or a flash drive. Any other fees, such as costs related to employee time to redact data or to search for and retrieve data, are not permissible under the Data Practices Act. In other words, if your agency does charge a flat fee, it must comply with the copy cost limitations in the Data Practices Act, and your agency should be able to describe what costs are included in that rate. If your agency cannot justify those costs, then your agency may need to recalculate the copy cost fees it's assessing to ensure it complies with the requirements of the law. One last slide, though, as we're talking about responding to requests for body camera data. Or excuse me, one last side thought as we're talking about responding to requests for body camera data. As I noted earlier, most requests for body camera data come from data subjects and are governed under Section 13.04, which means that the deadline to provide access to the data is 10 business days. The Commissioner of Administration has issued advisory opinions explaining that the language of Section 13.04 does not offer any exceptions or processes for an entity to extend that 10 business day deadline. Our office recognizes that it's likely difficult for most law enforcement agencies to provide a copy of redacted body camera data within this short timeline, but we do encourage you to work toward providing access as best you can within that deadline, such as providing access on a rolling basis and prioritizing body camera data requests. Practically speaking, the legislature would need to amend the Data Practices Act to give entities more flexibility when it comes to the time in which an agency must respond to requests for body camera data. All right, our fourth question this afternoon involves inspection. As a reminder, Section 13.825, Subdivision 4, states that a data subject may inspect the unredacted portions of a body camera video where that individual can be seen or heard. So, a question we've seen come up is whether a data subject can give informed consent to allow a third party or other non-data subject the ability to inspect an unredacted copy of body camera data. No, data subjects cannot provide informed consent to allow a third party to inspect unredacted body camera data. Let's walk through this analysis. Section 13.825, Subdivision 2, classifies body camera data as private when the data are not part of an active investigation. Meanwhile, Section 13.825, Subdivision 4, provides the requirements related to who may access private body camera data. Under Subdivision 4, each individual who appears or can be heard in the data are considered data subjects. So, the body camera data depicting each individual in the video would be classified as private data on each of those respective individuals. Meanwhile, Section 13.825, Subdivision 4, provides body camera data subjects with a special right to see private data on other individuals when inspecting body camera data in person. However, the body camera data about other data subjects is still classified as private data on those individuals. In other words, the private data classification on other individuals doesn't change when requesters come in to inspect body camera data in which they appear. Rather, the law permits data subjects special access to private data on other individuals, which isn't typically allowed in other contexts without informed consent of those other data subjects. More importantly, the primary requester cannot provide informed consent to allow other third parties, for example, an attorney, to view the private data on the other data subjects. Rather, your agency would need to obtain the informed consent of those other data subjects before a third party could come in and inspect unredacted body camera data. In short, a data subject's ability to inspect unredacted body camera data about others is a special right of access to private data on others under Section 13.825, Subdivision 4, and a data subject cannot transfer that special right to anyone else. Of course, a third party could still request a copy of the body camera data with the informed consent of a data subject, but others who did not consent to the release would still need to be redacted. All right, our next question. We've received several questions from law enforcement agencies about sharing body camera data with another agency. So the question that comes up is whether sharing that public body camera data among law enforcement agencies is permitted. As we always say, it depends is a good answer to a data practices question, and that's the case here. The applicable analysis for whether you can share body camera data depends on whether the data are part of an active investigation. So I'll lay out what to keep in mind. To remind everyone, Section 13.825, Subdivision 2A3, states that if body camera data are part of an active investigation, then those data are governed under Section 13.82, Subdivision 7, which means the data are classified as confidential, and you'd be looking to the data sharing requirements under Section 13.82. Specifically, Section 13.82, Subdivision 24 states that law enforcement agencies can share information provided the exchanged information is pertinent and necessary to the requesting agency in initiating, furthering, or completing an investigation. In other words, your agency would need to determine whether sharing the body camera footage that are active investigative data is pertinent and necessary for the requesting agency's purposes. The law doesn't define pertinent and necessary, and your agency should have policies and procedures in place for how to make these determinations when another agency may ask for confidential, active investigative data. From a practical standpoint, your agency will likely want to have a conversation with the requesting law enforcement agency to ask why the other agency needs the requested body camera data so your staff can make the applicable determinations as to whether disclosure of the data that are part of an active investigation is indeed pertinent and necessary to the other agency's investigation. If your agency determines that the pertinent and necessary standard is met, then you can share the body camera data with the other agency. However, once a criminal investigation becomes inactive, then any associated body camera data revert to being governed under Section 13.825. Likewise, if the body camera data never become associated with a criminal investigation, then Section 13.825 governs the data all along. In these situations, your agency would need to look to Section 13.825, subdivisions 7 and 8. Specifically, Section 13.825, Subdivision 8 states that body camera data may be shared or disseminated to another law enforcement agency upon meeting the standards for requesting access to data as provided in Subdivision 7. The language of Section 13.825, Subdivision 7 states that each law enforcement agency must create written procedures that allow law enforcement personnel to access not public body camera data only when they have a legitimate specified law enforcement purpose. This terminology isn't defined in law, but your agency should have some definitions and explanations of what is considered a legitimate and specified law enforcement purpose. In short, your agency would need to review its written body camera procedures to determine whether the other agency's access to the body camera data would be for a legitimate specified law enforcement purpose as described in your procedures. If so, then you'd be able to disclose the data to the other agency. Lastly, Section 13.825, or excuse me, Section 13.82, Subdivision 15 does allow law enforcement agencies to disclose body camera data to other agencies or the public when the disclosure would be in the public benefit. Specifically, an agency must determine such a disclosure will aid the law enforcement process, promote public safety, or dispel widespread rumor or unrest. Again, these terms are not defined in statute, and your agency should have some policies and procedures to help determine whether a situation warrants disclosure of body camera data under these public benefit standards. Okay, one last question this afternoon, and it relates to traffic accidents and state accident reports. Specifically, there will be times when someone who's entitled to obtain a copy of a state accident report, such as an insurance company, will also request any body camera data that are related to the accident. The question is whether the body camera data could be disclosed alongside the copy of the state accident report. So the current answer here is no. Your agency cannot also provide not public body camera data in addition to the state accident report. Specifically, neither Section 169.09, Subdivision 13, nor Section 13.825 contain any language that suggests that law enforcement agencies may also provide access to not public body camera data when an authorized third party requests a state accident report. Of course, if a body camera data subject, such as a driver who was involved in the accident, asks for a copy of the body camera data in addition to the state accident report, then that data subject would be able to access the portions of the video in which they can be seen or heard. However, a third party, such as an insurance company, would be able to obtain a copy of the body camera data only if the third party had obtained informed consent from the data subject. In these situations, your agency would need to redact any other data subjects as well as undercover officers. However, any on-duty peace officers should not be redacted. But as you'll see on this slide, there is a large but here. Just this past weekend, the legislature passed a bill that will amend Section 13.825 to allow the individuals identified in Section 169.09, Subdivision 13, to obtain a copy of unredacted body camera data that document a collision investigation. The new language requires a requester to make the request in writing and provide a copy of the accident report related to the body camera data. And the requester can use the data only for the purposes of processing insurance claims or as evidence in a proceeding related to the collisions. The requester is also prohibited from redisclosing the body camera data and could be subject to penalties for failing to comply with this limitation. Additionally, law enforcement agencies may withhold body camera data if there is a compelling reason to believe disclosure would interfere with an active criminal investigation, the data are clearly offensive to common sensibilities, or the data are classified as not public by other sections of the Data Practices Act. This bill has not yet been signed by the governor, but assuming that it will be, this new language will go into effect on July 1st, 2025. If you want to see the specific language, you can search for House File 2432 on the Minnesota Legislative Reviser's website. From there, you'll want to look for Article 9, Section 5 in that bill. As a final note, I'd encourage you all to sign up for our email list if you haven't done so already. We do send out a legislative update email every July that highlights various changes to data practices laws. And we will certainly include information about this new language in our legislative update. Okay, so that's our overview of body camera videos and the questions that we've been receiving. We do have time to discuss any questions that you all have. And please remember to send those to all panelists so we can make sure to see them. If we happen to be silent during this open Q&A period, don't worry, your audio is probably still working. We're just reading your questions and making sure that we've got the right answers. But a few reminders on this slide that the slide deck is available on our website, and you can access the recording on our YouTube page within the next couple of days. I'll also be putting an evaluation in the polling panel here shortly, so if you'd please fill that out, let us know how we did, what other topics you'd like to see in the future. We'd greatly appreciate it. And so I will pause there, and then we'll start in on the Q&A.
Thanks, Casey. This is Ellen with the DPO, and I can get started with the first question. This question asks, the question relates to body-worn camera recordings documenting deadly use of force, discharge of a firearm, my screen just changed, my apologies, or a use of force resulting in substantial bodily harm. These are the public triggers, but do we still have to redact each individual with the exception of a peace officer? Or should there be any redaction at all? This is a great question, and I think there is room for further clarity in the language in 13825. So as Casey mentioned earlier, under subdivision 4, when individuals are requesting copies of data, normally you would be redacting other individuals in the footage besides the data subject requester. But here we have public triggers under subdivision 2. And so when those public triggers occur, I don't think you would be redacting those other individuals in the footage. I think you would just be providing that footage without the redactions that are specified in subdivision 4, with the exception of classifications elsewhere. So 13.825 subdivision 2A5 does state that data that are not public under other provisions of this chapter retain that classification. I think this is mostly going to come into play with those protected identities that law enforcement have to protect under 13.82 subdivision 17. So that would include undercover officers. It would include certain victims and witnesses, depending on whether they meet those qualifications. So I would take a look and see if you have any protected identities when you have that public footage, if you're providing that in response to a request. Hope that helps.
Okay, the next question is, what about community service officers or civilian crime scene staff who appear in body camera data? So I think the question is, what do they need to be redacted? What about those folks? So if it's private, inactive data or just private body camera data, on-duty peace officers that are not undercover cannot be redacted, but everyone else is still a data subject. And so those other folks, they will need to be redacted, or unless you have consent, then you don't have to redact them. So even CISOs, firefighters, paramedics, other government employees that might appear in body cameras, only on duty, not undercover peace officers would remain unredacted in any sort of private body camera data.
Okay, so we've got a twofer here, and I'm just making sure that folks can see this. What happens if you receive many redacted video requests at the same time and do not have staffing or available time to answer the request in the 10-day window? Are we in statutory violation? Technically, yes. The requirement is to for data subject requests is that you do have to respond within 10 business days, and there's no exception for that. And so our office certainly recognizes that is a challenge to comply with that, especially with staffing levels and the amount of work that goes into redacting body camera footage. And so we totally understand that aspect. And the best suggestion that we have for you, or the best suggestion that I can offer, is to have a conversation with the requester and just to give them the context and explain to them that, hey, there's a lot of data that need to be redacted. And then, of course, prioritize that request, provide access to data. If you get, if you have, let's say, 5 videos that need to be redacted and you get 2 of them done in one day, maybe provide access to those first 2 videos. And then continue to roll those out over time, and that may help mitigate the concern from the requester on that front. Really the best suggestion that we have on this front is to maybe chat with your local legislators or talk with your various, professional organizations about this very real challenge to see whether or not there might be a way to amend the law to allow a little more flexibility in the future. Of course, we wouldn't advocate for that. We'd put that all on you and how that may want to go, but that would be perhaps the only way that you could kind of alleviate some of that pressure with that 10 business date deadline. The second question here, for unredacted viewing on site, confirming this is not the full unedited video, but the unedited clips where the requesting data subject is seen or heard. Yes, that is correct. So if a data subject wants to inspect their body camera footage, they can see the portions where they can be seen or heard unredacted. So imagine you have a 1-hour long video, but the data subject only appears in the first 10 minutes of that video. The data subject can see the first 10 minutes unredacted. The data subject doesn't get access to those other portions where your officers may be interviewing other witnesses, or they may be talking with each other. Really, the data subjects only get access to the portions where they can be seen or heard. And so they only get that portion. That portion can be unredacted. If they then ask for a copy, then they only get those first 10 minutes with all of the other data subjects redacted at that point.
Okay, next question. Most of our requests come from insurance agencies and law firms. We charge search and retrieval costs for them, and we include the time to search through the entire video for appearances of the subject. Is this an acceptable practice? I'm going to kind of answer this a couple different times because I think it will depend on who is making the request here. So let's say that you have a request for body camera footage and it's from a company like the insurance agency, it's from a neighbor, it's from someone who has informed consent from the data subject to get access to that data. Your copy cost structure in that event would be under Minnesota Statutes 13. I think you can charge the actual cost, which include the search and retrieval time is what I was going to say. So you can go through that video, that's the time to search for the retrieval where that data subject can be seen, right, or heard. And so I think that is part of the search and retrieval cost that you can charge. I think when it comes to attorneys or law firms, if the request is from an attorney that is representing the data subject making the request, I think this is more than just an informed consent. Here, I think that attorney is maybe acting as the data subject in those instances. So I don't think you could charge for that search and retrieval time when it comes to the body camera footage. So that time spent going through the videos searching for that data subject with those attorney requests, I don't think would fall under the copy cost structure that you could charge under 13.04 for those data subject requests, right? So I think it will depend on who the requester is, and we're more than happy to chat about that if you have those requests come across your desk.
All right, this is a tough one. If a data subject and a protected party are talking at the same time in body camera footage, an identity of the protected party would or could be revealed. Do you redact that audio or no? I think that it's going to depend on kind of what the video is, what the audio is. Is it possible that they're talking over each other? So in fact, the audio is sufficiently distorted so that you can't necessarily tell. Unfortunately, the Data Practices Act does not help us when private data of one person comes up against the private data of another person. And so ultimately, you're going to have to take a look at the video, look at the context, and make a determination about who is going to get access. Ultimately, someone has to be able to get access, so you can't withhold it from both data subjects. It's either going to be about both. It might be about both of them. It might be about one of them. Someone's going to be able, must be able to get access. So again, looking at the context, making a decision, and then being consistent across the video is probably your best bet. But these are really tough, and there isn't a very easy, clean answer that I can give you on that one.
So I am just going to follow up on my previous question just to make sure that folks, because I've got a good example here. If we have a vehicle accident where driver one requests the body camera data, they would only get the portions where they are seen or heard, or do we have to release the portions where the officer is sitting in the squad, preparing the report, running names, cards, etc.? No, in this situation, they would only get the portions where they can be seen or heard. You do not have to also include the portions where the officer is sitting alone in his or her squad car, preparing reports. If you cannot see the data subject in those situations, they do not get access to those portions of the video. And so it would only be the portions where the data subject can be seen or heard.
All right. So I'll hop to the next question. How does 1382 subdivision 13 play into body camera data? Victims can potentially get active investigative data under this provision. Does it include body camera data? This is a great question. So for those of you not as familiar, Minnesota Statutes 1382 subdivision 13 is essentially an access provision for crime victims. And so a crime victim can submit a written request to the prosecuting authority to get access to investigative data. And this can be when the case is active. So the the victim goes to the prosecutor, asks for this active investigative data, and then the prosecutor can make a determination as to whether releasing that data would be permitted under subdivision 13. They can withhold this active investigative data if they think the release of it would interfere with this active investigation, or if they think that request is prompted by a desire on the part of that requester to engage in unlawful activities. It's not clear whether body camera data falls under this provision. So really in 13825, subdivision, oh, I just lost it, 13825, subdivision 2A, Casey or someone can step in if they want to find it, basically says that body camera data that are part of an active investigation are treated under 1382 subdivision 7, right? And 1382 subdivision 7 classifies these data as confidential unless one of the triggers occur, and then provides specific access or public classifications depending on other things in subdivision 7. It doesn't specify subdivision 13. So I think this is going to be a judgment call for the prosecutor when they get these requests from the crime victims. So when the crime victim makes a request, the prosecutor is going to have to determine, excuse me, whether or not this subdivision 13 request would include the active investigative data that is the body camera footage, because the language under 1382 subdivision 13, subdivision 7, and 13.825 just does not address it. So it will be a risk assessment for that prosecutor.
Okay, so it is 1:46, so we're a minute over our promised end time, and so I think we will pause there for the day. But do not fret if you submitted a question. We will follow up with you. We've got contact information. We've got your names. We'll write down your questions. And so if you didn't hear your answer over our Q&A session here, someone from our office will follow up with you within the next day or so and answer that question that you had. So we're certainly happy to continue to have that conversation with you going forward. But all that said, thank you so much for attending and sending in your questions this afternoon. Do stay tuned for a Gov delivery notice with our upcoming trainings. We sent one out recently, but we will be hosting another free webinar on June 6th. We're planning on holding another free webinar in July to give a legislative update. We are also hosting an Intro to Data Practices remote workshop on June 17th. You can sign up for these trainings on our website. And again, you can learn more about the upcoming trainings by signing up for our email list. Thank you again for attending, and have a good afternoon.